edition of Ask Michael Ehline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. That's right. We never know when the thought police are going to take down this channel. How you guys doing? I am attorney Michael Ehline. And as most of you already know, I'm an attorney licensed to practice law in California and Texas. And I primarily do personal injury law. So good seeing you. Yabba dabba doo, and all of you. And yes, I've been trying the methylene blue out. And so far, I don't notice anything really appreciable. You know, watching Alex Jones and some of these other guys, you'd think that it was like the Holy Messiah reincarnated as some miracle substance. But I'm doing it. When I take my son to judo, I always, the sensei lets me use the mat to stretch. And so my son will do the judo class and I'll stretch, and that's been helping a lot. And I'll try to do some pull-ups and things like that. But anyways, guys, hey, what's going on? Let's OTVO. So tomorrow I have a show scheduled with BZ Watchdog where we're going to go on and talk about his false arrest case that he won. And we're going to have a retired police officer who was a whistleblower. And obviously, when you're a whistleblower, you no longer are welcome at the police department, right? And we're going to have him come on and we're going to do a reaction video to what happened to BZ Watchdog. And then hopefully, maybe I'll start it a little bit early, Let's OTVO, so I can talk a little bit about your case, you and Brick's case, to try to sort of make heads or tails of what's going on. Just really quickly, I'm going to see if I can adjust this camera just a wee bit to get a little bit better of a, there we go. I think that frame's a little bit better. How's it going, Simba B? So yeah, Let's OTVO, Simba B. So today we're going to talk a little bit about the Lane Myers case again, and this is going to be covering the second half of his last appearance on the Rule 10 motion, or the Rule 10 hearing, 10.1, I believe, in Arizona. And again, I only practice law in California or Texas, so I'm not practicing law in Arizona. I'm merely narrating my understanding of the law and how I would apply it if this was in California or Texas. Now, what we discussed last time is that there is a rule called Rule 10 in Arizona where you can seek to have the judge removed and replaced. And you have two ways you can do it. One is a peremptory challenge as a matter of right, which would be the equivalent of what we would use in California called 170.6. CCP 170.6 would allow me to do a peremptory challenge as a matter of right one time in a case. So if, let's say, a crummy judge that I don't like, well, I can't say, I'm an officer of the court, so I'm not supposed to say bad things about judges, unfortunately. But let's say there's a judge that I think wrongly decides cases, okay? And I've had this judge before, for example, and I don't like that judge. I can file the 170.6, a peremptory challenge, and have that judge removed and replaced with a new judge. However, that the lottery gets me stuck with another judge that I may like even less. And so it's like a chess game. You never know what you're going to get, like a box of chocolates, right? So you never know what you're going to get with a peremptory challenge. And then the second way in California you could do it after you've done your peremptory is if you get stuck with a really crummy judge who has a difficult time perceiving the law or the facts, or has some kind of a bias against you that's appreciable and you think you can prove, you would file a 170.1, a challenge for cause. Well, under Rule 10.1 in Arizona, it appears as though this rule is similar, but it combines both of those procedures that we would use in California. Hey, Dad, good seeing you. Love you, Dad. Hey, Stomper, how you guys doing? And notice I have the chat set up now to where it's on the screen in the far right, so you guys can see yourselves chatting and the audience can see you chatting as well. Then, of course, anybody who has a super chat or wants to buy memberships or whatever, I'll always make sure to give you recognition, because that's one of the main ways I'm able to support the channel and make it to where it's not a total wash, because as you know, I'm a lawyer and I could be working on cases. So I do these YouTube shows to try and show my support for the patriot community and people who believe in natural law. And I try to support people who society at large may not support. Anytime the government doesn't like somebody, I have a tendency to like that person even more. So Lane Myers is one of those guys who stands up for his rights. He got kicked out of and arrested falsely at a city council meeting, and I think that is the nexus of this whole case, for saying boo. And it was an anti-Second Amendment rally with a bunch of commies, in my opinion, in the audience, all cheering for this mayor or city council person in Arizona. I think it was Pima County, if I'm not mistaken. Put it in the comments if I am. And at the same time those people were applauding, Lane, with his MAGA hat on and his video cameras, his iPhones, said boo at about the same volume and decibels as the audience. And of course, promptly the Chairman Mao, or whoever it was that ran the council, immediately had the police come and have him arrested, and basically violated his First Amendment rights in this limited public forum. And it appears as though a prosecutor at the city attorney's office went up against Lane and tried to prosecute him for this. Believe it or not, I mean, this is unbelievable to me. And that's what got me interested in this case, because it reminded me of like something you'd find in communist China or under like Joe Stalin's regime, right? And so Lane apparently found out that and again, guys, correct me if I'm wrong, because I do have a law practice and I don't know all of the facts as intimately as Reluctant Prophet or This is a Public Service, because I also have a family to feed. And unfortunately, I'm not able to feed my family doing a YouTube channel, but I'll fill in the blanks that they can't fill in, because I've got over 20 years practice as a lawyer and doing appellate law and things of that nature. Thank you, Let's OTVO. Let's OTVO just said, how will we ever know when the free press is silenced? So Let's OTVO it appears as though he picked up a membership for 12 months, and I appreciate that, brother. That helps me support the channel quite a bit. So in any event, it appears as though this particular prosecutor, I think his name is Matt Walker, is married to a woman who works for a public university as a law professor, if I'm not mistaken, another like a left-wing university somewhere in Arizona. And well, they're all left-wing, right? I mean, all universities are they not? I mean, tell me one other than Liberty University that isn't, all right? And I'll eat my hat. So what ended up happening is, I guess Lane went to the university or made a phone call to this person. And as a result, his wife was forced to sign a letter of resignation because she's an officer of the court. I guess she's a lawyer, and common law wife, by the way. And so Lane got upset, and somehow or another, it came to be that he reached out to this woman who is married to the prosecutor who was going after Lane. And I guess Lane got those charges dismissed, but they should have never been brought based upon my information. And so he wanted to petition this woman who worked for the government for redress of grievances. And she brought some claims against him for harassment under this very vague and ambiguous, and I believe unconstitutional harassment statute that the Arizona legislature is in the process of rewording, because it's so bad that as applied, anybody could be convicted of harassment, because it's based upon the opinion of this alleged harassee. So, and again, throw me in the comments if there's anything that I'm missing, guys, because I'm all about being able to give you the right information. Okay, a clerical staff member, copy that. So I guess she was a clerical staff member, copy that. All right. I'm just looking at the comments here. So much easier to read the chat. I'm glad you like it. So yeah, in any event, I'm just looking at the comments, trying to get locked in here if I'm missing anything. Common law, he couldn't even commit to her. So, okay, I don't know. Let me see here. Wow, so many incompetent lawyers about to grad you. All right, so trying to just kind of really quickly, I don't want to miss anything. But good seeing you, Dad. I always crack up when I see you and I say, hey, Dad, because it reminds me of having a dad. And obviously, you guys know my dad passed away a couple of years ago from Agent Orange poisoning from Vietnam after we were lied to about the Gulf of Tonkin. which forced a lot of people to get drafted and go to war. So another reason why I do kind of hold a grudge against unlimited power lying with the state. So back on point. Ultimately, what ended up happening is charges were brought against Lane because he did a YouTube channel dedicated to exposing what he feels is the corruption with the Arizona prosecutor's office. And I guess the wife of one of the prosecutors, Matt Walker, is alleged that she was being harassed. And as a result, one thing led to another. And you can, look at some of my other videos or go to Reluctant Prophet or This Is a Public Service to fill in the blanks on their channels. But one thing led to another. And Lane's YouTube channel ultimately led to him being charged with multiple felonies for harassment and things of this nature. It's unbelievable. And apparently all this stemmed from one phone call and then him making videos talking about how he wanted to redress her and her husband for redress of grievances, both public officials, both working for the state. And I guess he gave out her webpage on the university system with her contact info, and a lot of people started contacting her. And a lot of people who don't like Lane Myers, obviously, were probably contacting the judge too, hoping that could somehow get Lane into trouble, into hot water. And a judge found on the record that Lane was responsible for these other people who were leaving her these horrible phone messages when he never said to leave horrible messages. He just said petition for redress. And so a lot of people, it was public record, so it's not like he was giving out her home address or anything like that. And one thing led to another, and now he sits in jail, languishing, awaiting trial. And hey, Ralph, good seeing you. And so as a result of this, he was found at a preliminary hearing for injunctive relief for a restraining order to be a danger by the court. And this particular judge promised him before he was incarcerated that he would have access to the law library. And it turns out that particular law library had been abolished over 2 years ago. And so Lane was unable to prepare an adequate defense. And he was basically pro se. And he'd had other lawyers who were brought in as a friend of the court, for example, associate counsel, but he was lead, but he was unable to receive prison mail, pleadings, unable to do motions, unable to work on his case from jail. And the judge alluded, this particular trial judge, I think his name was Metcalf, correct me if I'm wrong, alluded to it's Lane's fault because he elected to represent himself. And that's why he couldn't file timely motions. And Lane made a brilliant argument before the second judge, who was brought in, I guess, to take Lane's plea and also hear Lane's arguments on this Rule 10 motion to have the other judge recused as a matter of bias and being basically against Lane's case. And so we heard Lane's arguments yesterday, and you can check that out on my YouTube channel. I have that video. It was almost like 2.5 hours. Totally burned out from that show from yesterday. Yeah. And so Lane allegedly was going to enter a plea, but it turns out that he wasn't able to enter the plea that he wanted to because he had to make all these admissions and confessions on the record that he didn't believe in, that he didn't believe were true. And so this female judge, the second judge, would not allow him to enter the plea because she felt that it was not knowingly and voluntarily being entered into, which would negate the plea. And so that happened after this argument, this oral argument that you're going to hear right now. But really quickly, there's a lot of you who don't understand procedural rules. And so I want to break it down to you to give you a better idea of how things work. So typically, and I don't know about Arizona, but based on what I've read, it sounds like it's very similar to California or Texas. What would happen is the movant or the moving party will file a motion. And a motion is simply something that tells the court that you want movement. You want to move the court to do something, to take action. So that's why they call it a motion, right? Because you're asking for someone to take motion, an officer of the court, in this case, the judge, to go into motion to do something. And once that motion is filed, you have a statutory period of time to file the motion, number one. So you have a statutory period of time to move the court to do something from the time something's happened to you. And if you blow that time, you're in violation of a procedural guideline, which could blow out your case. Now, Lane, being pro per, has the advantage of Balistreri versus Pacifica Police Department, which is a Ninth Circuit case, which basically restates what judges should already know, which is that courts should not deny a pro se litigant a fair hearing on the merits of their claim due to ignorance of technical or procedural requirements. And they have to give broad deference to excuse a movement or a pro se litigant if they do make some kind of a procedural or technical error. But if it's a substantive error, they don't get the deference. Okay, they're treated more like a lawyer. So that's an advantage of being pro se or being pro per, which means you're just representing yourself. Okay, hopefully, give me a bunch of ones if you understand so far. So when someone files that motion, then the prosecutor has, or in this case, a prosecutor, or the opposing party, if it's a civil case, right, has a certain amount of time. Typically, it's like, 10 or 15 days to file their opposition brief, right? And then I believe you have 5 or 10 days to file your reply to their opposition. And you want to keep it brief. Obviously, if you get crazy and you start making a lot of conclusory statements and stuff like that, the judge's eyes are going to glaze over and you're going to lose. And I know this because I used to extern for the California Court of Appeal, and I've worked for several judges, and I understand how they operate, how they think. They've got hundreds of files and they get burned out, and it usually is going to be handled by a law clerk. And the law clerk will then bring it to the attention of the judge, but the judge is going to give in my opinion, most of how they rule based upon the research that their law clerk has done. And typically a law clerk isn't going to be someone like in law school. It's going to be a paid attorney, someone who might have 10, 15, 20 years experience, who is hired as a law clerk to act as the right-hand man or woman of the judge. Hopefully you guys are understanding this. Now, it could also be a law student, though. It could also be a law student. So you just don't know. And again, you could end up with a judge like Judge Ball, who appears to have very little experience as a judge, who just worked for a bunch of judges and decided to try to become a judge. And I have a problem with people like that. I really believe that if you're going to be a judge, you need to first be out in private practice for a while, learn the game, learn the pulse of the people, and not just try to become automatically a black-robed taskmaster. You should know what it takes to run a practice and how difficult it is. That's just my opinion. In this particular case, Lane was not able to comply with all of these moving and replying requirements because he was locked up and he was denied his right, after being promised, to use a law library. He was given limited access to an online system that only allows you to do state law research. But there's also federal cases that could come into play that he's not able to look up. So he was really, in my opinion, hamstrung as to what he could and could not do. And this particular judge said, well, hey, you didn't file this motion in time to recuse me. So or to maybe even enter a plea or whatever it might be. It could be anything. It appears as though the judge's standard response would be file a motion. And then Lane's response back is, well, how can I file a motion when you won't entertain any of them because they're not being filed timely, because I'm not able to get my paperwork. I'm not able to do anything. And this is, in his mind, this is a kangaroo court. And so Lane has been saying that this whole time. This is unacceptable. Now, Old Driver says there's no common law marriage in Arizona. And yes, I do understand that, but I'm of the mind that the government shouldn't be involved in your decision to be married. I don't understand why there has to be any kind of government involvement in your decision to be married to someone. To me, it's absurd. So in my mind, a common law marriage is a marriage that you make between yourself and your God. And usually it's recorded in your family Bible. That's how it always was done. There was no such thing as marriage licenses until much later on in the history of this country. So when I say common law marriage, I mean common law marriage, like law of the commoner, right? Not that you had to have it recorded with the government so they could tax you and try and destroy your life, which is basically, I can't understand, I can't conceive of any other reason why the government wants to be involved in your marriage other than so they can double tax you or whatever it is that they do, marriage penalty, just a way to make you a ward of the state. So In this particular case, and Bob, I am a lawyer, but I'm only licensed to practice law in California and Texas. So I'm just sort of giving you my narrative of my understanding of this case and how I would handle it if it was handled in California or Texas. And obviously I'm biased in favor of Lane and patriotic people who always test the government. Protest. I believe in protest, the Latin word for test. I'm all for testing the government like our founding fathers were. Remember, the First Amendment was not just about religious freedom or freedom of association. It was about being able to challenge the government, to test the government, because absolute power corrupts absolutely. And so what we found is that Lane was recording in court as is his right under, I think it's Rule 11H, if I'm not mistaken, in Arizona, to audio record in court. Well, this particular prosecutor doesn't like Lane recording in court. I guess Lane beat him. And so he filed a petition to make it impossible for people to audio record in court, unless under certain circumstances, I guess. And so only the judge is recording. And we're noticing that certain parts of these hearings are being cut out, or somehow you're not able to hear them. And that's the whole reason. All courts are supposed to be courts of record. So to me, it's unfair that a prosecutor who's married to an alleged victim has so much power, and he's gotten the state bar and he's gotten court commissioners to sign on to this. And everybody knows it's because of Lane Myers. So to me, it just shows overwhelming bias by the whole Arizona court system against Lane Myers. And it seems to me that this is a case that should have been removed to federal court on many levels. But again, because Lane has been denied his procedural due process, not being able to file motions, not being able to respond to motions, being seriously hamstrung because he elected to represent himself, and somehow that's a terrible thing, he's now been put in this position where he was basically forced into, man, I may have to enter a plea bargain because there's no way I can adequately defend myself. And so he goes before another judge to enter this plea, and also argues in favor of this Rule 10 motion that he wants the other judge to send out to another judge. And this is where we left off last time. So we left off with Lane arguing that the prior judge was biased against him, and he argued Rule 10 and Rule 10.1. And now the prosecutor is making her argument saying, well, Lane hasn't passed the threshold of proving that somehow this judge has some kind of an interest against Lane. But that's only part of the test. So hearing her at the outset, automatically I was like, wait a minute, that's a really poor argument, because Lane's entire argument was that this judge had expressed a bias against him for representing himself. That's it. And he was basically saying, it's your fault. It's your fault that I'm not able to get motions in a timely fashion. And so Lane was, in my opinion, those are great arguments. I think Lane did a terrific job, and he wasn't raising his voice. He wasn't cutting people off. I mean, Lane has come a long, long way. Initially, that was my biggest issue with Lane, is that, cutting people off and swearing and outbursts in court, it basically creates a bias to where you're not able to get a fair hearing. And I think that he is just doing a tremendous job at arguing his case. And this is where we left off last time. Let me see here. Jason Zwack, good seeing you, man. And Jason, I'd love to have you on too. So Jason is a free man upon the land in Arizona, and he seems to know a lot about Arizona law. So I'd love to have him come on as a guest and tell me what he thinks about this case as well at some point. And that's right. I agree with you. If Lane calls his partner his wife, that's all I need. She's his wife. That's the end of it. Absolutely. Of course. It's ridiculous to say otherwise. Why on earth does the state have to be a party in my relationship with my significant other? That's why I always had an issue with this gay marriage thing. It's like, dude, if you want to be married to a dude, that's up to you. But why do you have to force it on me and my family and make a law that it's legal? Why do I have to have a license to marry my wife? Why? Why does it have to be recognized by you? That's my choice. I'm a free man. Same issue I have with property taxes. Why on earth do we have property taxes? That flies in the face of life, liberty, and the pursuit of happiness.
You never own your property if there are property taxes, period. You don't own it. The government owns your property. And of course, this all sort of revolves around the Federal Reserve private banking system that and Jekyll Island and the takeover by the banksters of our country. I think it was 1913, if I'm not mistaken. And so in order to make all of us chattel property of the government, there had to be a way to make sure, using the census and with licenses, to make sure that we all get a number assigned to us at birth, a social security number, and there's a value put on each of our lives by the state. So when they borrow money, they can show the creditors, hey, this person's worth this much, this person's worth that much, and we'll make sure to pay back this loan that you created out of thin air from fiat currency to pay you back. Total joke, a gimmick system, in my opinion. But we'll talk about that at another time. And then tell Mike about open mics, Jason. Yeah, well, we'll talk about all that stuff, man. I definitely want to have people on as guests because I learn a lot from my audience as well. So I'm not here to try to tell you that I'm the top dog lawyer or whatever. I make my money from doing catastrophic injury cases, all right, and police shootings and tight handcuff cases involving finger and hand amputations from cutting off the blood supply and damaging the nerves. So that is how I support my wife and kids. And occasionally when you guys buy one of my books or give me a super chat or something like that, that definitely helps out because it helps me justify to my wife that, hey, honey, you've got to let me do these shows because I need it for my own spiritual well-being to give something back to the people that I love the most, which are true Americans who love their country. And so that's how it works. So with respect to Lane Myers, we're going to get into the second part. Hey, Jody Shiloh, we're going to get into the second part of the hearing the other day. And this is, again, a big shout out to This Is a Public Service. Let me just go ahead and present. I got to do the share screen thing. Just give me a second, guys. Just got to find the right one. So what I've been doing is I got This Is a Public Services live stream where he was able apparently to record this hearing. Or somehow we got a decent audio recording because the court's audio recording sucks. But I don't know how he was able to do it. But what I've done here is I've used the transcript. See if I can, there we go. I've used the transcript, and when I play it back, I'll scroll with my finger. So give me a bunch of ones for myself that I was able to find a way to use the YouTube transcript to let you guys read along. And let me see here. Life Under the Microscope. Good seeing you, brother. Really love seeing you, man. And Dave's channel, why do customers resist showing receipts? I don't know, Dave. I don't know. I think the only ones who usually resist showing receipts are the ones who stole something. I think he's alluding to some of the shorts that I've been posting. So I've been doing a different approach on my shorts to try to engage my audience. I'll do lawyer shorts where I'll find some interesting topic, like someone robbing from a store, and then I'll ask a question like, is this person guilty of a crime? Should this person have to show their receipt? And I'll let the audience engage, and then I'll come back in and I'll tell them what I think in the comments is a way to try to engage my audience more, as opposed to just telling people things. It allows me, when I'm doing a deposition or something and I'm bored to death, I can sit there and answer some questions and things like that. So it says here, Dad says open mic night at the court. Right. Undercover brother. Kinetic Customs, you're funny, man. So let's go ahead and get into, and I think this is the prosecutor. I think, what is her name? Rachel Stiles, I think. This is the prosecutor so what happened is the husband of the alleged victim forwarded felony charges to the county prosecutor because he is this other attorney is a city attorney. So I think city attorneys in Arizona, like in LA, only handle misdemeanors and below, like infractions. So he packages up this case involving his wife and sends it off to get it prosecuted with felonies against Lane to obviously someone who he's probably friends with over at the county prosecutor's office. So that's the power of the state for you. Don't mess with the wife of a prosecutor, guys. Now, to me, that has the appearance of impropriety in and of itself. To have that kind of power to basically forward a charge that was brought against your wife to another prosecutor. And I mean, I think it's ripe for some kind of judicial oversight or federal oversight, because it's Lane who's languishing in prison, not the wife, not the husband. And the fact that they're trying to take away everyone's First Amendment right to audio record in their own causes because of what Lane did, beating this prosecutor in court, it just all has the appearance of impropriety to me. So that's why I wanted to get involved and kind of cover this case a little bit more, because Reluctant Prophet, and this is a public service, they're not lawyers, but they're awesome. But I want to fill in the blanks that they're not able to fill in with some legal arguments and based on that general understanding of general legal principles and as I understand them. So what I'm going to do is we left off the other day at, you see, at 49:19, I guess. And we're going to let her make her arguments. So you'll know it's the prosecutor when you hear a woman's voice, or the judge is also a woman. And then if you hear the dude, that's going to be Lane.
So that issue that he's brought up, this has been an ongoing issue in the court hearings where we have a lot of disruption before court even gets started, where we've had issues with the audio and the video streaming. As I said, even people we're going to do the personal audio. We have people that were using their phones and turning them in such a way to try to film. This is a harassment case against this victim has been harassed on social media. The people.
Okay, but that's a red herring, because whether or not someone is using their phone to video record, that's already a violation of the law. You're not allowed to film in court unless you have permission of, I believe, the presiding judge or the actual judge in the court. The rule that Lane was abiding by was an audio recording rule. So this sounds like a red herring already. And I just don't like the way she conflates things, because it assumes facts not in evidence. It lacks foundation, and it's basically argumentative. And I believe it's being done to poison Lane against the judge.
Who have been coming to court are all connected with social media. So there is a concern about the victim suffering additional harassment throughout the process, which she has had additional harassment that's been done to her throughout the process with people with the calling and things happening in the case. So the court, in just ordering the live stream and not having people audio record, is because people weren't complying with court staff. There was no way to monitor to make sure they were only audio recording. So the court made sure it was available.
Well, there's never any way to know if someone's audio recording, and because somebody could bring in a hidden recorder. So objection assumes facts not in evidence, argumentative, lacks foundation, calls for speculation, vague and ambiguous.
To the public where they could record it from as they wanted with the audio stream, but then they weren't able to then film the victim or film anything they weren't supposed to be filming. In talking about the no bond hearing, there was no bond hearing held in this case. It actually took place over 2 days. There was testimony given at the no bond hearing. There were exhibits presented at the no bond hearing. So a full no bond hearing did happen. So Mr. Myers is referencing 7.4 when it transfers, but he's not indicated any change in circumstances warranting another review. I think he's under the false impression that this court is holding 2 no bond hearings.
Well, no, that's not what he's saying. What Lane is saying is that when the case gets transferred to a new judge, that he's entitled de novo to a new hearing, and that didn't take place. Or at least he's entitled to have the judge rule on whether or not he should have a new hearing. And in this case, Lane provided case law that said that he is entitled to it. So I don't really understand what her argument is, but it seems quite circular.
Every time somebody's held without bond, but that's not the case. It's extremely rare that after a first no bond hearing is held, that a second one is held, because there's usually nothing new that would be presented at it.
I'm not aware of any. Are you? Just because I obviously
I haven't. I'm sorry.
I just wondered if you were aware of any where no bond, had a second no bond hearing. I'm not aware of any, but
I cannot think of a.
Well, but not being aware of it happening doesn't mean that that the law doesn't say that you're entitled to one. So, okay.
Single case where somebody has had a second no bond hearing. And in this case, he was indicted on the 2 felonies for which he was held without bond. So
and Lane is saying that the facts and circumstances had changed because at least one of the felonies was reduced to a misdemeanor, which does create new evidence and new facts that are where he would be entitled to a new hearing. So, and he made the arguments on the record. So these are all now ripe for appeal or for a writ. In this case, I think they call it a special action or something, if I'm not mistaken.
those 2 felonies are still in place and have been the entire time. So I think he just has this, he sees it in the rule, but in Rule 7.4, it's not mandatory. It's not shall, it's may. And that's very different. And I think that there were some.
Right. So in the actual statute, it does say may. And so let me give you the distinction. So may means it's permissive. It means that the court can if he wants to or she wants to, whereas shall is mandatory. But what Lane is saying is no. The Court of Appeal in Arizona, a Court of Appeals, I guess they call it there, has ruled that no, if you comport the statute with the case law, in fact, Lane was absolutely entitled to a new no bond hearing. And it's not permissive, it's mandatory. And so she keeps going back to the actual black letter law, but if you shepherdize the statute, according to Lane, in fact, he was entitled to a second hearing.
Material circumstances that would warrant a new no bond hearing that could potentially happen, but there are none in this case. And when he's referencing the time.
And according to Lane at the last hearing, there were new facts and circumstances. I just pointed out one, which is that some of the charges had been changed. And so that is a new fact or circumstance that should at least allow him a new hearing. Now, it doesn't mean the judge is going to grant it. I mean, it appears as though the fix is in either way.
Right, when he was with, where Mr. Carbon was representing, and Mr. Carbon had filed a motion, we had the argument on it, and then Mr. Carbon contacted the court and asked the court to withdraw it from consideration. So then the court stopped considering it until then Mr. Myers filed his own. But then the court wanted time to be able to review Mr. Myers' pleading.
Well, so what happened is co-counsel with Lane wanted to withdraw that motion that Lane wanted to be heard about the new hearing. And Lane, when he was locked up, tried to file the new motion, but he was not able to file it in a timely fashion because of being locked up. So what Lane did is he brought it with him to court and tried to file it with the judge at that time. And so rather than the judge take the matter under submission, based on my memory, the judge outright denied the motion without even giving it any consideration at all, which is one of the reasons why Lane wants to get rid of the judge.
And set it for a separate hearing. And so that's the time frame is actually very short from when the court was setting it for when Mr. Myers had actually filed his motion. Regarding speedy trial, I think Mr. Myers just doesn't fully understand there's this the time limit for speedy trial to get the case to trial, but then there's a whole separate time frame for sentencing that has its own speedy trial, per se, under 26.3.
And what Lane is saying is that from the time I'm convicted, you have to sentence me as well within my speedy trial time. You can't just convict me and then send me off to prison and then wait until my speedy trial time period is over to move forward with your sentence. And so that's the argument that he's making. And the prosecutor is saying that's not true. There's a separate time once you're convicted because you've already had your speedy trial and you were convicted. And she's saying that that's not true. Now, I have not shepherdized the statute. So if anybody wants to help me, Lane apparently has. And so far, I'll be honest with you guys, Lane's been right about everything, so I don't know why he would be wrong about this. Give me a bunch of ones if you agree.
It has a separate time where it's mandatory with the sentencing. And I think Mr. Myers just may not understand there's actually 2 separate time frames for that. But regardless, the date for the trial in this case is set well within speedy trial time. As I noted in the motion. And so there's nothing in this case that's indicating that Judge Metcalf has any bias or prejudice.
So really quickly, because I can't see the screen when I'm scrolling, so let me just take a look and see if anyone's got any questions or wants to add anything. Mr. Osgood, they want him to take a deal. They won't let it go to trial. They have no case. He never threatened anyone. That is from Rune Dragon. Hey, what's going on, SW Observer? Good seeing you, my man. Hey, though, my Swedish friend. Hopefully you're brushing up on your Arabic lessons since your government flooded your country with sub-Saharan Africans and people who don't speak your language. Let me see here. Yes, Top Shelf Anarchy said it's Val, Sean Marley. I just emailed you about a legal doctrine rooted in the first principles and due process. Never done before. Would love 5 minutes of your time. Okay, we'll talk about it, man. I'm cool with that. I'm just going through before we continue on. I don't want to give you guys just yak away without seeing if you guys have. Hey, Dave's channel says he appreciates the shorts. Thanks, Dave. I try to have fun with it. I mean, look, if we can't laugh and have a good time and talk about the law, you're not going to remember it. So I'm one of these people who believes in play theory. So, for example, when you're a boxer and you're doing heavy sparring, you're not going to be able to retain the information because you're in fear of getting hit. And so, but when you play and you spar in a playful manner, if you look at lion cubs or wolves, you learn how to fight by play. And so I don't believe in fear-based teaching. And I believe that if I can make you laugh, you're going to retain that information the same way that like if we're doing judo and I'm teaching a sotomari or some kind of throw or something like that, that if we're having a good time and it's just not like, oh, like screaming at you like a samurai, you're not going to learn. Most people shut down. So I believe in play theory. And that's why I try to make people laugh and use funny short videos and stuff because you'll remember better. So hopefully you guys appreciate that about what I'm trying to do. In any event, let's get back into the transcript. I just want to set it up to where you can see everything. But yeah, that's what it's all about, man. Is having a good time, making people laugh. And that's right. So Kinetic Custom says, if you're not laughing when you're living, write that crap down. Yeah, that's right, man. You're going to retain far more information when it's a playful thing. And it goes right back to like sparring. When animals learn how to fight, they start with playing. Look at your kittens. Look at dogs. They learn how to fight and they learn how to protect and defend themselves first by playing and by having fun. And so I always try to do that. I try to make people laugh and have a good time. And that way we'll understand and things will sink in better. All right, let's get back into it.
It just seems purely that these are disagreements with the judge's rulings. And so for those reasons, I don't think he has met his standard. It is his burden to show that this judge should be removed for cause. And he has not given anything other than disagreements with his ruling to support his argument. And so we would ask for it to be denied.
Well, I disagree with that. I mean, Lane made it very clear that the court was basically blaming Lane, that it was his choice to represent himself. And that's why I'm not able to rule on your motions. Because if you'd had a regular lawyer, well, he would have been able to file the motions and I would have been able to hear them. So, and of course, Lane got really upset and Lane was kicked out of the court. And under the rules, according to Lane, when someone's removed from the court, the judge has to give them an opportunity to come back in the room after things have cooled down. And that did not happen here, which would be akin to finding someone in contempt of court without having a hearing on the merits of contempt. I mean, if you look at it that way, it makes more sense. Hopefully you guys agree. Give me a bunch of ones if you agree that I got the facts right on that.
Ms. Stiles, were you present on the May 12th? And I believe Mr. Meyer said May 19th hearings.
When it's over, I left my
He
stuff in your car.
said that he
Leave my keys. No,
filed
Yeah,
wrote the
I'm gonna do
motion
it.
right after the May 12th hearing, which corresponds with the transcript. And then on the May 19th hearing is when he provided the motion. Were you present at those?
Yes.
Okay. He indicates that he felt that, and by he, I should make that more specific so the record's clear. Mr. Meyer seemed to indicate.
And this is the judge, by the way. There's two women, so you have to listen very closely. But this is the judge now speaking.
That Judge Metcalf was denying his motions or not setting his motions or delay in setting his motions. He kind of used a variety of things because he was self-represented versus if he were represented. Did you notice anything in Judge Metcalf's rulings that appeared to be treating Mr. Myers differently because he was self-represented versus being represented by an attorney? Or in his actions in court? Doesn't even need to be a ruling.
No, Your Honor, I think.
I mean, come on. She's asking the prosecutor, basically trying to cross-examine the prosecutor. Is this somehow she's going to be able to provide some kind of witness testimony that would somehow negate Lane's arguments? I mean, that's crazy to me, right? I mean, give me a break, guys. I mean, I think that line of questioning was wrongly decided by this trial judge. No way in hell does the prosecutor's opinion about what the judge did matter with respect to the defendant's right to the speedy trial. The only time I've ever seen anything like that ever happen, that remotely ever happened like that, is in a case involving a judge advocate general. Do you guys know what a judge advocate general is? Okay, in a military tribunal, a judge can act as the juror, the prosecutor, and the defense attorney. At least the judge has the ability to do those things. But in a case like this, the torch of prosecutorial power does not pass back and forth from the judge to the prosecutor, okay? I don't see any valid basis or reasoning, at least if I was in California or Texas, to ask the prosecutor who is deciding whether or not this guy gets thrown in jail for the rest of his life, what is your opinion of the judge? Do you think the judge was biased? And obviously, most judges are former prosecutors, so we already know that this prosecutor, likely on her path towards more government power, is going to run for judge or mayor or governor, right? And so why on earth would a judge ask a prosecutor, and how could that be a valid basis to make a ruling as a judge? You guys tell me. I'm befuddled by this. It doesn't make any sense to me at all. It's just like mind-boggling to me that the judge would ask the prosecutor, do you think the judge was biased against the defendant? Oh, you didn't? Oh, you don't? Oh, I mean, just keep listening. This is crazy.
The filings in court. Mr. Myers does have advisory counsel, so he has the ability to get documents to his advisory.
And that's not true. So she's making a false statement, saying that Lane has the ability to get documents to his advisory counsel when he has no way to use the phone during business hours, right? When the advisory counsel is probably in court or working on another case, when the prison does not deliver pleadings and papers to the defendant while he's locked up in a timely fashion that would enable the defendant to be able to properly respond within those statutory periods. And then you have the trial judge himself saying, had you not chosen to represent yourself, you would have been able to timely file this motion. Clearly, to me, if this was in California, I would argue under 170.1 that the judge has a clear bias or the inability to perceive the law and the facts in an unbiased manner. That would be my argument. Let's keep going.
Counsel in advance of court, where his advisory counsel can assist him with filing things.
Not in a timely fashion. That is not
So
true.
I don't think it was an issue with the judge having an issue that Mr. Myers is representing himself, but he does have a mechanism.
No, he does not.
Advisory counsel.
Again, he does not have a mechanism through advisory counsel to adequately prepare a defense. That was the whole basis of the fact that Lane had to file the motion in open court. He did not have the ability to file it in advance because advisory counsel has no way to contact Lane, and Lane has no way to contact advisory counsel. And for advisory counsel to drive down to the court, go through the metal detector, take his freaking shoes off, and spend his entire day to go visit Lane, right? Impossible. I'm telling you, I've been practicing law for over 20 years. There is no way that I would be able to every other day be able to contact my client. You've got to arrange a meeting with the prison officials. Basically, it would have completely put me into bankruptcy court. What she is saying lacks any and all merit if you're looking at it from the position of someone who's trying to get a fair trial. Impossible. Well, he has access to advisory counsel. Look, I have access to my Glock 21 in California when I'm driving my car down the road. But the law was written in such a way that it has to be in a locked container and the magazine can't be in the mag well. So when I get attacked, sure, I have access to a weapon, but when seconds count, I don't. And in this case, when days count, when minutes count, when I've got statutory filing guidelines, I don't. So for her to say this to me is quite disingenuous if this had been happening in California or Texas. I'm blown away that she could say these things with a straight face, to be honest. It just doesn't make any sense, but let's keep going.
Wish to file things without filing them and handing them to the clerk in court. And in court, there's some confusion about what they were filing. One of the documents Mr. Myers had filed prior to that actually was his motion for.
And by the way, I don't know how it works in this court, but I would typically say objection, Your Honor, assumes facts not in evidence. Objection lacks foundation, and I would demand a ruling on the record. I don't know if Lane understands that or if at this particular hearing, Lane was disallowed his right to object or his lawyer was disallowed the right to object. I don't understand the decorum and procedural guidelines, but for me, I would want to make objections on the record. And if I was disallowed from making objections on the record, I would make immediately file written objections, and I would demand that the court rule on my objections for purposes of appeal. And that's why I was asking Lane in the last conversation I had with him, do you have access to the criminal practice and procedure books? And he said he's not even allowed to receive those in jail. So if Lane's not allowed to receive literature or practice guides while he's in jail, do you really think that he's getting a fair trial when he's the one who's preparing his defense? And this advisory counsel is simply there as an assistant and in effect his law clerk, right? Think about that. Give me a bunch of ones if you agree with me that it's insane that if what Lane is saying is true, he can't even get a practice guide so he could make the proper objections and create a proper record on appeal.
The redetermination on the no bond hearing. Mr. Myers, when he gave it in court, it never actually got filed. And so the next hearing, I had to actually notify the court that it actually wasn't filed and it wasn't in the agave because of that problem. And so I think what the judge is indicating is he has advisory counsel to assist him with that. He's just not utilizing it.
He's not utilizing it. So she is making a statement that's not true, by the way. The judge never said that Lane wasn't utilizing his advisory counsel. What the judge said is you elected to represent yourself, and that's why you're not able to file motions on time. That's what I heard. Is that what you guys heard? I mean, if I'm wrong, correct me, because the last thing I want to do is make a false statement on the record. But based on my recollection, that's what the judge found. The judge basically made a finding of fact on the record and then kicked Lane out of the court and didn't invite him back in to make counter arguments. And so what the prosecutor is saying, from my understanding, is totally untrue and disingenuous. I don't approve. I don't approve of what she's doing. I think it's really unfair to Lane for her to make these statements. They're clearly not buttressed by any facts. Let's keep going.
Thank you. I wanted to verify your. Mr. Myers, Ms. House did not use all of her time, so if you want a little extra, I can give you 10 minutes for any rebuttal.
Oh, yeah, that's fine.
Like to make.
Thank you. The first thing is advisory counsel is not my secretary. He's not my paralegal. He's not my law clerk. He's advising. When I need advice, I ask for advice.
Good job, Lane.
There's nothing in the procedure, like the agreement of advisory counsel where I call him up and I say, I need to file this motion. Can you pick it up at the jail and go file it? He is not my secretary. And the state keeps trying to pigeonhole my advisory counsel as my secretary, my law clerk, and my runner for like they use runners to bring motions over from the building to the court. That's not his purpose. He's there to give me legal advice. He's not there to file motions on my behalf. The motions I'm required to file the motions. I write the motions, I file the motions. He's not my secretary. And she's been saying this throughout the whole trial, how, well, he's getting his due process at the jail. I know he has no way of defending himself at the jail, but he has this advisory counsel who can do all this for him. No, they can't. They have other cases.
That's
they have
right.
other things to do. They don't have time to sit around and take hours out of their day to come run my errands or file my motions. And furthermore,
True.
How would I get it to him unless they come to the jail? So what do? Call up Resnick and demand that he comes to the jail and pick this motion up and take it before file it? He's not
Exactly.
having any obligation in his agreement as my advisory counsel to come to the jail and pick up motions and take them to court and file them. He's there, his obligations are to provide me with sound legal advice. They gotta get off this, and you know, she filed a notice, and you know, I don't even know why you asked her opinion really, because you didn't ask my opinion.
I was trying to understand, I understood your opinion to be that you considered it and those things, and I just wondered if she saw something different in the way he was treating you than he did people.
Well, she's taking testimony from the prosecutor and basically questioning her as a witness, in my opinion, to determine whether or not Lane got a fair hearing on the merits. Look, first of all, she was not sworn in to give testimony. She's not being hired as an expert, and any opinions that she gives are going to be biased against Lane. So Elaine is right on the money, guys. I mean, I think that was a wrong decision of the court to ask the prosecutor whether or not the prosecutor felt that Lane was being mistreated. To me, it's just another situation where it appears as though there's bias emanating from the bench in favor of the people of the state.
People with counsel. That's all.
I mean, but that's her opinion. What do you think she did?
And that's all. Honestly, I didn't know what her opinion was, so that's why I asked.
Well, her opinion is anything against me.
That's right.
Against me.
That's right.
I mean, now I want to really talk about this bail thing. I know you said you've never seen it, but that's shocking. For 14 years on the bench, you haven't seen this when it's clearly in the rule and there's a bunch of case law and the motion contains case law, and their response was a recipe for apple pie, which talked about a different court, and they literally changed the wording of the rules in their reply to gaslight the court into not taking my motion seriously. You're absolute. Why would it say that if you're transferred to a court, you can get a new hearing? It doesn't say, and there's new facts. It says, if transferred to a new court, comma, now we all had to pass English in here to get our college degrees. Well, a comma is not an and, okay? If it said, transferred to a new court and new material facts, it wouldn't have a comma, it would have the word and. It says, if transferred to a new court, comma, if new material facts, or something about that applies to the conditions of release, which don't apply, you know, they can't pay the money or something like that, which doesn't apply. There's plenty of case law that says you get it. Why would you get re-examine bail eligibility? Under what pretense could you re-examine bail eligibility if there wasn't another hearing? The whole point of the wording is, if it's transferred to a new court, you can re-examine bail eligibility. So if you've never seen it, I don't know how, because you clearly have the right to file a motion to re-examine bail eligibility. And then when you look at the case law, how is that interpreted? It's a de novo review. Well, a de novo review for somebody that is not held eligible is a new evidentiary hearing, and there's case law on that. And she took my case law in her motion, and she responded, and she made up her own version of what it said.
Well, that's what they always do.
To even address the merits of the most binding statement in the Rule 7 motion, which was the Mendez versus Robertson case, where it clearly says two instances is or, you know, transferred or new facts. She completely ignored that in her motion. I mean, her motion, we're not even hearing on that right now, but it's literally a red for apple pie. It's not a response to what I wrote. And absolutely, positively, you can file a motion and have somebody who's held without bail, because that's the whole point of having to re-examine bail eligibility. There's only one class of defendants where we re-examine bail eligibility. Every single defendant is eligible for bail as a matter of right, except the very limited group that are held without bail because of the class of their crime. So if you're going to re-examine bail eligibility, well, everybody other than those people are already eligible. So clearly, it's intending for you to re-examine people who are not held eligible. And the case law supports that. And the case law says that when you examine bail eligibility, the only way you get due process when the state's trying to hold you without bail is with an evidentiary hearing. She turned that into something completely different in her response. And the court just buys right into this. I'm not saying you, ma'am, but I mean, you just asked her if you've never seen it. Well, that's scary. I'm scared now. I'm really scared.
Me too.
Because the whole world knows that you're entitled to a bail evidentiary, a re-examine hearing, if it's transferred to another court. The rules allow for substantive review. Whenever the person's case is transferred to a different court, Rule 7 .4 shall be held on the record as soon as possible. You know, right to due process. It's all in the case law. How is it not a rule that you're entitled as a matter of right for? I don't understand what I'm reading. We all passed English, like I said. She tries to turn may, right? So may. Well, ma'am, people could ask, ma'am, you ask your teacher, may I go to the bathroom? Yes, you may. Or you ask somebody, are you going to the beach today? Well, I may or may not. There's absolutely multiple definitions of the word may, okay?
Well, as a matter of legal jurisprudence, may is permissive and shall is mandatory. So that is an area where Lane is going to have to struggle. However, he did say that rule was interpreted by case law, that when it goes to a new judge, that it does become mandatory. So that's what I wanted to focus on here. And I have not read the case yet. I'd like to. If anybody knows the case that he's referencing, please ship it over to me so I can take a look at it.
There's when it says the court may, yeah, well, I filed the motion. Can we have my hearing? Yes, we may have your hearing. It's not, well, we may or may not have your hearing. This is not English. This is law. It's not surpluses. It's not, an English competition test. It's comma. And she keeps saying and. No, if they wanted an and there, if it required a change of court and new facts, they would not have a comma there. They would have the word and. So then anybody reading that at a 6th grade reading level, which the rules are maybe 8th grade, they would read, okay, so the conditions of getting a new bond hearing are transfer to a new court and material facts. If they wanted it to say that, it would say that. And Metcalf already got called out in the appeals court for not understanding the plain language of the rules. It literally says when the court is re-examine means de novo. How could you have how could we examine, let's give her argument some food for thought, which we shouldn't even do, but
So de novo just means like a fresh look, and I need to read the case law, but if the statute says may, that does mean permissive. And unless it was abrogated by case law, that it's automatic de novo review, this is shaky ground that Lane's on for this. However, there's other procedural issues that I'm concerned with that still show a pattern and practice of denial of due process rights.
Well, how could you have re-examination of bail without another hearing? The rule also says conditions of release. Well, I'm not asking to review my conditions of release because I don't have any conditions of release because I've been held not eligible for bail. That means we're going to take the part of the rule that says re-examine bail eligibility and we're going to re-examine it. So we're going to have a new hearing because if you don't have the new hearing, you didn't give me a de novo review. So I don't understand what I'm reading that they're not, I know that the whole point, the trick of law is my wife's an attorney who's a law clerk for this court. So I understand, she tells me all the time, lawyers get paid to lie, right? Lawyers get paid to twist your words. Lawyers get paid to write stuff on paper that doesn't make sense, that just sounds good.
You have thought about, I had 10:18 to be stopped, so about 11 minutes, but I'll give you another minute.
Okay. I'm just
I want to give you.
This isn't the bail eligibility hearing. I just want a fair chance to, because if the state has no problem meeting their burden, what are they so scared of? Why wouldn't they just come in there and show the same evidence and rubber stamp it? It's because I had a counsel. I wanted to continue it. I wanted to represent myself at the bail eligibility hearing. The counsel asked less than 5 questions. I didn't get to testify. We didn't present any of the evidence I wanted to present. So they know that if I get this bail eligibility hearing, that I'm going to handle it differently than the first one, and that I'm going to get bail because there is no way for them to meet the burden of proof evident if I'm asking the questions. They just, and they had Tracy Miller, who was working at the prosecutor's office a few months before.
So what he's saying is that the original bail eligibility hearing, he was denied due process. And so one of the things that he could have done is moved for a writ of mandate or a writ of prohibition, or maybe file an interlocutory appeal on a question of law alone. But again, if he's locked up, he doesn't really have the ability to do that. So let's keep going.
He's friends with them at the U of A. I know you worked at the prosecutor, but you worked under Barbara Wall, who would never bring these charges. And so I know you have a different, I'm not lumping you into that same category as Tracy Miller. And I also tried to get rid of Tracy Miller under Rule 10, but Pardon wouldn't file the motion because he's got to kiss everybody's butt around here because he's got to, try to run for judge. I don't.
So that would be an argument for ineffective assistance of counsel. And so that is something else that Lane will have if he is convicted ultimately, that he was ineffectively represented when he goes up on appeal.
But, this is about transferring the judge. I don't think me and Metcalf need to be in the same. I'm not comfortable. I mean, it's not just about being comfortable. I understand there has to be facts. I filed the affidavit. The judge saying it's not going to helping you means it's going to be hurting you. I mean, he removed me from court, and I said I'll behave. He said nope, doesn't matter, remove him. There's no other way. He's just blatantly being impartial towards me. He has inherent bias towards a pro se defendant when he says, "Oh, that's what you get for being pro se."
Okay, I need you to.
You're good.
You're okay, all right.
Yeah.
Thank you, Mr. Meyer. I'm looking at Rule 10.1, which reads, a party is entitled to a change of judge if the party shows that the assigned judge's interest or prejudice would prevent a fair and impartial hearing and trial. There were multiple, the best word to use, I guess, multiple allegations that Mr. Myers used in his motion to show, or from his view, that Judge Metcalf had an interest or prejudice that would prevent a fair trial. As I mentioned, I did see the state's response this morning. I'm going to deny the motion to strike the response. However, I'm not going to consider the written response, but I am going to allow it to be in the file. But I have the first allegation by Mr. Myers was a denial of media coverage. And while you can agree or disagree with that ruling, I don't believe the denial of it shows an interest or prejudice that would prevent a fair or impartial hearing. The second one was a violation of the admin order. Again, I don't find that shows an interest or interest or prejudice that would prevent a fair trial. With regard to the speedy trial, under Rule 8, an individual who's in custody, such as Mr. Myers, must have a trial within 150 days. And based upon the calculations done by my office, he's well within the speedy trial by having a trial on July 22nd. Additionally, I think he may even be, if we're convicted at trial and sentenced within the 30 days, still within the speedy trial, because I calculate it to be sometime in the 1st of September. But even if you're right, sir, and it's August 11th, you may be a couple of days after, but under Rule 26.3, that's where the sentencing has a speedy component in it, and that is 30 days from the time of conviction. So I disagree that with Mr. Myers, and my legal basis, in case he wants to appeal this, is that the rules require 150 days under Rule 8 for trial, and then the Rule 26.3 requires 30 days for.
So basically, the court is at least giving Lane the opportunity to have a clear record that this is her interpretation of the statute. And if Lane disagrees that there is not an additional 30 days to sentence from the time of conviction, that he's got an adequate record on appeal.
Sentencing. I don't believe that 30 days, based on my review of the rules and the law, is incorporated within that 150, but would be an extension of that. And based upon that, I do not find it is a violation of speedy trial based on that legal analysis. With regard to denial of the bail on re-exam, again, looking at Rule 7.4C, it states, generally on motion or on its own, a court may re-examine bail eligibility or condition of release. And then there's some other information provided with that. And the last sentence is the court may hold oral argument or an evidentiary hearing. While I agree that Mr. Myers has a right to file a motion to reevaluate his conditions of release, based upon the rule, the court may or may not hear that motion. Again, I see no bias or prejudice if the court chooses not to hear a motion on review of these conditions, because that's within the court's discretion under Rule 7.4C1. With regard to the denial of a jury questionnaire, there's no right to a jury questionnaire. There's a right to a fair trial that can be done through voir dire questions. It doesn't need to be a questionnaire sent to the jury. There's been no information or evidence presented that having a jury questionnaire gets you any more or less bias prevention, and there's nothing in the court ruling that would show a bias or prejudice or interest of Judge Metcalf for denying a jury questionnaire. And just on an aside, of the trials we do hear, a very small percentage have jury questionnaires. Threat of retaliation was the last one. With regard to the information provided in Mr. Meyer's motion, it had a quote, "Don't threaten the court, it will not be good for you." That's not exactly what was said. Also in Mr. Meyer's motion, he indicated that this had to do with the violation of judicial conduct, judicial code of conduct that Mr. Meyer said. In referring to page 5 of the transcript that the court ordered, Mr. Meyer said, and this is on line 16, that's a violation of the Code of Judicial Conduct. The court's response was, "All right, you can file a complaint then." Mr. Myers then said, "You're going to get a lot of them." The court said, "All right." I don't find that to be at all argumentative or a threat to against Mr. Myers if he chose to file a judicial code of conduct complaints, clearly within his right, and clearly the court said, "Go ahead and file one." On the page 7, the court does says, "I don't like threats, it's not helping your case." And there is a discussion with regard to that, but again, there's no bias or prejudice shown right within that transcript or in the argument that Mr. Myers has made. So in considering all of the arguments and the law as the court views it, which I recognize is different than Mr. Myers, the court finds that there is no prejudice or interest that would prevent a fair trial shown on behalf of Judge Metcalf, and I will deny the 10.1. With regard to then, just also on the record, the court received a notice, I believe it came from Ms. Stiles' office, that procedurally today she had met with Mr. Myers before, and there may be a possible change.
Okay, so just really quickly, because I know you guys probably want to get some. So basically what the court has decided is that the statute says may, which is permissive. So the court has no duty to grant that second bail hearing. That's the court's finding on the record. And then the court has made findings that there's no bias or prejudice by the judge. So far, I haven't seen anything where the court addressed the basis for, I think, Lane's strongest argument in favor of a 10.1 is that the court said on the record that it was your choice to represent yourself, and that's why you're not able to file this paperwork. And so, or motions or responsive pleading. So that's disconcerting to me. The strongest argument that I believe Lane has is the one so far I haven't seen a ruling on. What do you guys think? So that's just my impression as a non-attorney in Arizona, just as a bystander or an outsider looking in. If this was in California or Texas, that would be, I believe, the strongest basis is that, hey, you went ahead and decided to represent yourself. So it's not my problem that you're not able to file motions or get responsive pleadings done in a timely fashion. All right, let's get back into it.
And I wanted to address a couple of issues with regard to that. One, whether there is a change of plea, because obviously that's the first question. 2, if there is a change of plea, I can certainly take that without issue, taking a plea. But then the case would go back to Judge Metcalf for sentencing. And just for the record, even if this court were to keep the case for sentencing based upon my current position, I don't have a caseload. So it would go back to Judge Metcalf if there were a violation of probation or conditions or anything. I don't know what the plea is. That's just a guess, given the charges and my experience, that it would be probation available. So, Mr. Resnick, Mr. Myers, I didn't know if you caught all that. Okay, good. Absolutely. Well, Mr. Resnick, I've had provided to me the rule number 22 and then the information provided by Mr. Kelly that's titled Motion to Affirm First Amendment Right. I'm going to order that these be filed. These were all consolidated in lowercase number, is that correct? These files? Were they physically consolidated or just consolidated for purposes of trial?
It's just for trial, so they're still separate.
I'm gonna have them filed in the 2025-1060, just so it's clear, but I'll note that they're in both cases, or consider them in both matters, for the record. Just for any appellate purposes that they may have. Okay, no, that's okay. And how did you all want to proceed? Mr. Myers, do you want to do the plea? Do you not want to do
Well, I
the
had some
plea?
questions about the plea itself, because the one I got, it seems like they've been going back and forth.
That happens.
Because it didn't look like anybody else was in jail.
Do you want me to?
Your Honor, I have a copy of the court.
Okay.
Copy.
Yeah, if you could hand that to me. Mr. Myers, Ms. Stiles is gonna hand me a copy just so I can follow what your concerns are, and if I can address them, great. If I can't, it's not a problem. You do not have to enter this plea today. If I do take a plea, I need to know you're doing it knowingly, intelligently, and voluntary, so I don't wanna do it if you feel any threats. But, I'm just looking at it so I can understand your questions.
Yeah, the first one didn't have that. Oh, go ahead.
And Your Honor, if the plea is accepted, the victim would just like to be heard. And then I know Mr. Myers was referencing the 85% language that was missing from the copy of the plea, so I got that inserted. We didn't realize that was missing.
Okay.
I did inform when Mr. Resnick asked me a question that obviously would still be the law regardless of that paragraph being in there, but to make sure it's.
Okay, so right now what we're getting into is where Lane is going to, it appears, enter a plea. And so 95% of criminal cases end up in a plea agreement where the criminal defendant will plead out to a lesser included offense in exchange for probation or something like that, where if he does do a violation, he goes right back and goes right back to hell again. So that's what it looks like is happening here. Hopefully you guys can still see the screen. I'm going to do it a little bit different this time so you guys can see me here. Do it.
Clear to everybody to put it in there.
Okay.
Judge, and the other issue that Mr. Myers had was the interplay between the operative terms of the plea and Rule 7, ARS 13-703. I spoke briefly with Ms. Stiles about that when Mr. Myers raised it to me. I guess the issue is consolidation, because once they're consolidated for trial, the judge is obliged to sentence the defendant as.
Hopefully you guys can hear what he's saying.
Which would not make him probationary.
But the issue is that when you're going to enter into a plea, you have to knowingly and voluntarily enter into the plea. So you have to agree. Basically, you're convicting yourself on the record. Give me a bunch of ones if you understand that. It can be very dangerous, especially when you don't feel like you did anything wrong. Let's keep going.
And I guess the state could waive 703 and the court could agree to waive 703 for purposes of the plea. But I think the issue was once they're consolidated, that would be consolidated for trial. Heard on some occasions, consolidated for trial. I wasn't advisory counsel at that point, so I'm not entirely sure procedurally whether or not they were or not. And so that was Mr. Myers' concern, and I think it's right to raise it. I imagine there's a way to fix that. But
Well, it looks like under the plea, I'm just looking at the top of page 2, because he's probation failing one vote.
Well, I mean, I don't.
I'll just get it later.
Maybe I'm just.
That's
What is
bigger
it?
stuff. That's not
Just
the
a
law
battery
says.
in my charger.
So Your Honor, for trial purposes, only for trial purposes,
I got several.
under the plea agreement, they're not
I just need the charger.
consolidated under the
Oh.
plea. And under the plea agreement, he has probation available in those.
It's all right.
And so
This will be done short.
that would be very clear. It's clear in the plea agreement,
it's
and it's very clear
I'll get it.
today. And so that he would not be be facing anything under 13.703 due to consolidation.
So, Mr. Myers, my experience with plea agreements is they often say things that, if you got right down to the law, would make them not probation available. My example is possession of certain drugs for sale. You can possess a certain drug for sale, and if it's a certain amount, it's probation available, assuming you have no priors and all that, right? So it's a probation available. You get over what they call over the threshold, 9 grams in some cases, for number of pills and other things. You get over that threshold, it becomes not probation available. So a plea offer that the state may offer.
So again, this is something that I need to explain to you. So just because Lane is going to agree to a plea agreement, the court still has to approve of it. And if a criminal defendant has prior offenses that fall within a certain guideline, a certain type of charge, there may be a statutory requirement that the judge gives a multiplier, for example, where, like you've had a third strike, right? You go to jail for life kind of a thing. Well, if you've got a prior felony and it falls within a sentencing guideline, just because you've entered into this plea agreement, it still has to be approved by the court. And of course, when does the court approve the plea agreement? After you've already convicted yourself. So just because he's doing this and he's getting a good faith agreement from the prosecutor, right? That this is the plea agreement that the state would accept, the judge would still have to sign off on it. And then the only valid argument that Lane would have would be on appeal, ineffective assistance of counsel. Here he's representing himself, right? Or he would try to do a petition to withdraw the plea. And that's not always going to be possible when you filed this waiver where you knowingly and voluntarily entered into the plea agreement. I'm hoping that I'm able to provide you guys with some information that you didn't otherwise know. So let me see here. Hey, Ryan Labs, good seeing you, man. Yeah, so Ryan Lab says a friend did a diversion, 364 days suspended, but then he was arrested leaving the court, and that was a violation of diversion, and he had to serve 365 days. Yeah, that's the problem is if you've got a really crummy prosecutor or a cop who doesn't like you, there's a possibility that there could be some retaliation where they try to violate you, because now they know if you do one little thing wrong and you're not squeaky clean, and of course they make it to where you can't leave the jurisdiction sometimes, that you might be in a real world of hurt. I mean, these plea agreements are no joke, guys. So yeah, let's keep listening.
In a case like that is you're facing prison, and this is obviously not you, but this is just my example. The person is facing prison for possession of methamphetamine for sale, and they've alleged over the threshold. They plead them to the same charge, possession of methamphetamine for sale, but they don't go with the threshold. So now they're probation available. So they're making, and that one might be a bad example, but they're making, because it's meth that I chose, they're making it probation available, even though with the amount, it would be no probation. So the same thing is true on certain cases. For example, somebody with a prior felony conviction may not be probation available. But if they drop that allegation, they're probation available. By doing this plea, saying that on the top of page 2, that the probation available term for the 5 is 3 years and for the 6 is 3 years, it is a probation available plea as I read it. So probation is available. Yes, it is available on both. If it was not available.
Okay, so it looks like the court is making a finding that probation is available and pre-approving the plea agreement. So Arizona has some things that may be a little bit different than what I'm used to, but let's keep listening.
The way the plea agreements that I've always seen will say something like, as to count 1, probation is not available. As to count 2, probation is available and it can be for 3 years. Or as to CR this, probation is not available, and as to CR this, probation is. The way this is written, it is probation available on both, and it is a contract on both. Probation is available to you. So again, that's a court's discretion. So it's not 100%.
Okay, yeah.
But it is available. And as
sort of like may is permissive and shall is mandatory. So the court's basically saying just because it's available, it doesn't mean I'm going to give it to you. So go ahead and enter your plea and we'll see what happens. That's basically how I read it.
the sentencing ranges.
Right, because I know the allegation of the priors and all that, I just wasn't sure because of the I wasn't sure if it was overlooked or, because these get a lot of copy and paste or?
Now, it's a very good question. I always look at, do the charges match? Okay, so you got a 5 and a 6 and probation periods that match with those. Are they probation available or not? And under the probation they are. The next really, it's all important, but the next really important thing to me is the special terms, because that's where unique things can be written into a plea that aren't standard. Because a lot of this other stuff is standard for everybody, regardless of what you're doing. But the special terms are not. And that has that the parties agree at the time of sentencing, and it cites a statute. The defendant shall be served with an injunction that prohibits the defendant from contacting the victim. The injunction does not expire and is valid for the defendant's natural life unless dismissal is granted pursuant to, and again, it cites that statute. So that's an important, unique feature of this plea that would be different than others. Don't see it. Absolutely.
Can't hear anything. So guys, look, this has been going on for like an hour and a half now, and I do have to run some errands. So let's go ahead and stop it at 1:22:54. We'll come back tomorrow in the morning, and then I'll do my BZ Watchdog show later in the day with that retired cop whistleblower guy. And we'll just go for it from there. But so far you can kind of see, and you already know the outcome. What ends up happening is the judge finds that Lane is incapable of voluntarily entering into this plea agreement, and he gets sent back to the slammer, back to the dungeon with his torture cuffs. And man, but make sure to hit that like and subscribe button. Hit that like and subscribe button, guys. Make sure to like and subscribe. Make sure to save. Let me take a look here. So Austin Rodriguez, I'm not sure what you're talking about. I'll have to go back and look at all this. There's a lot of comments that I haven't been able to see because I'm busy scrolling the transcript so you guys can read along with me, because the audio is so terrible. You know, I'm trying to help you guys. Yeah, well, I hope they would drop the case too, Austin, but it looks like they're out for blood, man. I'm trying, Dave. You know, it's not easy. I know like half you guys hate me because I'm taking a stance that's unpopular, but that's been my whole life, is supporting unpopular causes. So that's just the way it is. In any event, I hope you guys have a good day today. I'm sorry that Lane's still locked up. Be nice if there was a way that he could get out of there. So hopefully you guys learned something today, and that's the main thing for me, is that if I'm able to give you some teaching or something that can help you grow yourself in a way that's positive, whether you agree with me or disagree with me. And I'm hoping to have Lane on the show again, maybe next week. And I know that Chili DeCastro also is going to be doing at some point an interview with him. So we'll try to keep him in the news and keep people aware of what's going on as best as we can. Again, it's not easy. I got a business to run, so I'm doing what I can with the time that I have. But you're welcome, Sin City, and you're welcome, Simba B. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. Semper Fi, do or die.